seriousness of the state's case and additional suspects that must be arrested, thus there will be a risk of interference. Those are the grounds. The charges against Mr. Nandago were provided to us on 14 July. These were provided to us by the state prosecutor, Ms. Hinda, being charge 60, charge 61 and its alternative. However, during cross-examination yesterday, it transpired that the bundle of the D2 contains an additional 62 charge, or count 62, that is said to be of the applicant number 7 or against him. That should not be an issue that should detain us, because if one has regard to that charge, it's premised on the factual allegations that are also contained in charge 60 as well as 61. Therefore, they have been dealt with, those facts have been dealt with by the applicant in his founding affidavit extensively. So even though the applicant was under the impression that he's only charged with 60 and 61 and its alternative, the averments or the allegations contained in 62 for purposes of these proceedings have also been addressed in his affidavit. Your Worship, I'll now move over to the issues or the principles of bail in our jurisdiction. And I want to start off by referring this Honorable Court to the case of Boulder versus the state, where the court held as follows. The purpose of a bail inquiry is to assess whether the applicant is likely to stand trial, and the focus is on the probabilities apparent from the relative strength or deficiencies of the state's case, definite findings on the merits or demerits of a case, and or defense postulated. Definite findings on the merits or demerits of a case and or defense postulated are best left to the trial court. Those are issues for the trial court. The fact that an applicant is a foreign passport holder alone does not automatically mean that such a person is not entitled to bail in any circumstances. I refer the court to that specific issue, to that specific decision, because in that matter, the applicant or Mr. Boulder was a British national. All the applicant and applicant number 7 is a Namibian national. I also wish to refer the court to the principle that the correct approach in bail applications is that the court must lean in favor and will lean in favor of the liberty of an individual, provided that the interest of justice will not be prejudiced by granting bail. And that I invite the court to then also have regard to S versus Tlongwa, where it was stated that the correct approach to the decision of bail is that the court will always grant bail where possible and will lean in favor of and not against the liberty of the subject, provided that it is clear that the interest of justice will not be prejudiced thereby. The strength of the case, seriousness of the case, and the likely sentence to be imposed are interrelated to the determination of the likelihood that an accused would abscond instead of stand his trial. And I then refer the court to the decision of Ngipunya versus the state, where the court said the following: the question whether the appellant is likely to abscond is closely linked to the apparent strength of the state's case and the resultant sentence likely to be imposed. Justice Hanna in S versus Eugene and others also stated that in determining this question of abscondment, a court will have to have regard to various matters. The seriousness of the charge that the accused faces is one, but not, as has been judicially pointed out, in itself. I will come to that shortly. The judge said the relevance of the seriousness of the offense lies in the sentence which will probably follow upon a conviction. If the probable sentence is one of a substantial period of imprisonment, then there is obviously a greater incentive for the accused to avoid standing his trial than if the probable sentence is an affordable fine. I also then wish to invite the court to have regard to Still Ngipunya versus the state, where reference was made to the Lazarus Shaduka versus the state matter, where the court said correctly, where an